Half the country is saying something like ideologue, rogue judge, and the other half of the country is saying thorough, well-written opinion finally stands up bravely to the weaponization of the judicial system. Judge Eileen Cannon just tossed one of the Trump prosecutions. The core of the case is that Trump had thousands and thousands of documents, sensitive documents pertaining to national defense in his home. She held that the appointment of Special Prosecutor Jack Smith was unconstitutional from the get-go. It's a violation of the Appointments Clause. She goes through each and every one of these four statutes. She says, not this one, nope, not that one, nope, not this one. None of them. She says none of them authorize the appointment of a special prosecutor from outside the government by the Attorney General. Her analysis of these statutes, not crazy. She's running together the concept of dictum with the concept of an assumption. It is now virtually impossible that this case will be tried before the election in November. Stick with me, and I'm going to explain it to you straight down the middle. Hello, everyone, and welcome back. Today we're going to talk about the bombshell legal ruling down in Florida where Judge Eileen Cannon just tossed one of the Trump prosecutions. And she didn't just dismiss a few charges from that prosecution, she threw the whole thing out. Well, predictably, half the country is saying something like ideologue, rogue judge breaks with 40 years of precedent to exonerate Trump. And the other half of the country is saying thorough, well-written opinion finally stands up bravely to the weaponization of the judicial system. So who's right? And by the way, what exactly did she hold? If you're reading news reports of this, you probably don't know exactly what she held. Well, stick with me, and I'm going to explain it to you straight down the middle. Okay, so let's get started. First of all, which case is this? There's so many damn Trump prosecutions, it's hard to keep them straight. This is the prosecution happening down in Florida concerning documents, mishandling of documents. The core of the case is that Trump had thousands and thousands of sensitive documents pertaining to national defense in his home. Now, the charges in this case are a little unusual. Put aside the fact that the current president, Biden, also had boxes of sensitive documents in his home and he's not under indictment. But we're going to put that aside, not going to talk about the distinctive features of the charges in the case because they had nothing to do with the holding that Judge Cannon just reached on the basis of which she threw the case out. So what was that holding? Did she hold that the president is immune from these charges under presidential immunity, as decided recently by the United States Supreme Court? That's what the initial headlines told you, that this was a presidential immunity case. Well, guess what? Nothing to do with that. Had nothing to do with presidential immunity. Okay, so did she hold that the charges were politically motivated? Is that the basis on which she threw the whole case out? Nope, nothing to do with that. So what did she hold? She held that the appointment of Special Prosecutor Jack Smith was unconstitutional from the get-go. That when Attorney General Merrick Garland appointed Jack Smith from outside the government to assume the role of Special Prosecutor, that was unconstitutional, she held. So that's the question that's presented by the case. Is there something unconstitutional about the appointment of the Special Prosecutor? So, first question. People ask me, Professor, what is a special prosecutor? I don't really understand what that is. So let me take a couple of minutes and explain it to you. In the federal system, special prosecutors are people from outside the government who are brought in to investigate when there is suspicion that somebody inside the government might have committed a crime, somebody high up. So you get somebody from outside the government to investigate whether there's a crime that's been committed by somebody inside the government. That's typically what a special prosecutor is. Now, question. Are they good or bad, these special prosecutors? Is it a good idea to have them? Is it a bad idea to have them? Well, there's arguments on both sides. The argument in favor of the special prosecutor, you can probably imagine, is, hey, if you are investigating somebody high up in the federal government, you can't have that person investigated by somebody in the Department of Justice because it's an inside job. I mean, imagine if the Attorney General himself were suspected of committing a crime. What are you going to do? You're going to have that allegation investigated by the Attorney General of the United States? It doesn't make any sense. You got to bring somebody in from the outside to investigate somebody on the inside, or else the whole investigation would be an inside job. And of course, people say that goes in spades for the president himself. You can't have him investigated by the attorney general when the attorney general can be fired by the president anytime for any reason. So to avoid the appearance of impropriety and to ensure that you got a fair investigation, what you do is you bring somebody from the outside and you appoint them and you name them special prosecutor for that case. And by the way, there's a bunch of different names that these prosecutors have gone by: special prosecutor, special counsel, independent counsel. But what I just described to you is basically how it works with respect to all of them. Now, what's the opposite argument? The people who knock the special prosecutors say, hey, these special prosecutors can go rogue. They can be out of control. They're not subject to any checks on their discretion. And you can't be sure. Maybe they were appointed to go after somebody in particular. And how can we trust that they're going to exercise their judgment fairly? Well, you got to try to put some meat on those bones. What do people mean when they're making this allegation that special prosecutors can be out of control? One thing they point to is just the money that's available to them. Believe it or not, budgetary constraints are a very important part of what reins in prosecutors and puts some kind of limit on what they can do. And there's a fear that if prosecutors can spend too much money investigating one particular person, they're always going to be able to find some crime that they can charge the person with. It's the old fear of, show me the man and I'll find you a crime. So you might think that having a prosecutor with unlimited funds might be a problem. And guess what? These special prosecutors who are brought in these cases have unlimited funds. And that's what people raise a question about. So famously, Ken Starr, special prosecutor in one of the Clinton investigations, spent over $50 million investigating that case. And according to public records, it looks like Special Prosecutor Jack Smith has already spent $25 million on the documents case. And so, as I say, some people think this is just too much. And if you give a prosecutor that much money, they're going to be able to find something to pin on anybody. So those are the arguments for and against special prosecutors. But you know what? Those are policy arguments. They try to answer the question, is it a good idea to have a special prosecutor? That's not the legal question. It has got nothing to do with the constitutional question. Judge Cannon found that the appointment of the special prosecutor was unconstitutional. Not that it was a good idea, a bad idea, unconstitutional. Well, on what basis did she say that? Does the Constitution say anything specific about whether there can be special prosecutors? No, it does not. So what was the basis upon which Judge Cannon found this appointment unconstitutional? Well, she said it's a violation of the Appointments Clause. The Appointments Clause, what's that, Professor? The Appointments Clause, Article 2, Section 2, Clause 2 of the Constitution, it lays out procedures through which officers of the United States can be appointed. Well, hang on, what's an officer of the United States? Well, sometimes it can be a little confusing, but in this kind of case, it's very simple. An officer of the United States is anybody who can exercise official powers of the United States government. Is a special prosecutor an officer of the United States in that sense? You bet he is. Special prosecutors can order the FBI to do stuff. They can convene a grand jury. They can launch a prosecution. Those are very important, awesome powers that the federal government exercises, and the special prosecutor gets those powers for sure. He's an officer. So then you turn to the Appointments Clause and you look at it and you ask, well, how does the Appointments Clause permit officers of the United States to be appointed? And the Appointments Clause lays out two tracks, two pathways to the appointment of an officer. In track one, you're familiar with this, the president nominates an officer to be appointed, and the Senate gets to vote up or down, confirm or disconfirm. So the president can appoint an officer with the advice and consent of the Senate. Now hang on, does the president really do that with all the thousands of officers of the United States? No, of course not. There wouldn't be time enough to do that with a senatorial confirmation process, not the way it works for anything except the topmost officers. And the Constitution provides for that in the second part of the Appointments Clause. The second part of the Appointments Clause lays out track two, and it says that with respect to inferior officers, and that's the term the Constitution uses, Congress can pass a statute allowing inferior officers to be appointed by either the president or courts of law or heads of department. Forget about the Senate. If Congress passes a statute, the officer can be straight up appointed by the president, courts of law, or the head of a department. Well, did the president appoint the special prosecutor? No. Was he appointed by a court of law? No. Was he appointed by a head of a department? Yes, he was. He was appointed by the Attorney General, who's the head of the Justice Department. So he was appointed by head of a department. So where's the problem? Judge Cannon, where's the Appointments Clause problem? Well, the Appointments Clause requires, don't forget, and this is central to Track 2, that Congress passes a statute authorizing the head of the department to appoint that officer. Why is that important? Because the Appointments Clause is making sure that the legislative branch plays a checking role on the appointment of federal officers. It does not permit the executive department to create offices and name the people, to exercise the powers of that office without legislative oversight and a legislative role. In Track 1, the legislative check is provided by senatorial confirmation. In Track 2, where there's no role for the Senate, Congress has to pass a statute saying, yeah, for this officer, we're going to create his powers. Here's the office. We're going to create it. Here are the powers. And then you, head of department or president or court of law, you can appoint somebody to occupy that office. But in both tracks, there's an important legislative role. And in Track 2, the legislative role is that Congress, both the House and the Senate together, have to have passed a law saying that the head of the department can fill that office. So was there a statute? Did Congress pass a statute authorizing the Attorney General to appoint a special prosecutor? That becomes the question under the Appointments Clause. Is there a statute out there dealing with independent prosecutors and saying that the Attorney General can appoint them? Well, there was such a statute. For about 20 years, from the late 70s, post-Watergate, through about 1999, there was a statute. It was the Independent Counsel Statute, specifically addressing that and creating an office called the Independent Counsel and saying how the Independent Counsel was supposed to be appointed and creating the powers and specifying a lot of procedures with respect to the Independent Counsel. But that statute expired right around 1999. It was permitted to expire. A lot of people weren't crazy about it, and it expired by its own terms. Congress never reenacted it. So right now we have no statute specifically dealing with independent prosecutors. So I guess that's the end of the case, right? There's no statute. That's not the end of the case. So both before and after the Independent Counsel statute existed, the Attorney General of the United States did in fact appoint special prosecutors under other statutory authorizations, or what he claimed to be other statutory authorizations. And in this case, Merrick Garland, the Attorney General, said, wait a second, even without the Independent Counsel statute, I got four statutes that authorize me to appoint an independent prosecutor. Merrick Garland would say, look, there's all these regulations out there that permit me to appoint a special prosecutor, to which the judge, Judge Cannon, said, well, regulations don't do it. It has to be a congressional statute, and she's right about that. But Merrick Garland would say, well, what do you think these regulations are doing there? They're there because everybody understands that under these pre-existing statutes, I have the authority to appoint an independent prosecutor. That's why we got all these regulations saying how it's done and what the procedures are. So the case ends up focusing on and concentrating and turning on looking at these four different statutes that Jack Smith and Merrick Garland refer to and invoke as authorizing the Attorney General to appoint the special prosecutor. And Judge Cannon's opinion goes through each of these four statutes, and it's a 90-page opinion. And it's carefully written. It's very thorough. She goes through each and every one of these four statutes. She says, not this one. Nope, not that one. Nope, not this one. None of them. She says none of them authorize the appointment of a special prosecutor from outside the government by the Attorney General. Now, hang on a second. I just said that Attorney Generals have been doing this, and you've heard of some of these special prosecutors. Robert Mueller, special prosecutor investigating the Russian election interference allegations. Robert Hur, recently appointed special prosecutor to investigate President Biden's having all these documents in his home in Delaware. Under Judge Cannon's opinion, were all these special prosecutors acting unconstitutionally? Yes. Under her opinion, they're all unconstitutional. She goes through the statutes and she says, nope, not a one of them permit the Attorney General to reach out and appoint somebody from outside the government to investigate somebody inside the government. Now, I'm not going to go into these statutes in great detail. It would take too long and it's too complicated, but I'll give you a sense of what's at issue and what kinds of things she was saying about it. So, for example, I'll tell you about one of the statutes. One of the statutes says that the Attorney General can delegate special prosecutorial powers on somebody who's already inside the Department of Justice, somebody who already has a position in the Department of Justice. And Judge Cannon says, well, that's not going to work, because that's not what happened in this case. You appointed somebody from outside the government and made him special prosecutor. And don't forget, that's how special prosecutors have always been appointed. So you're always reaching to pull somebody from outside the government, typically a veteran prosecutor, but somebody not currently in the Department of Justice. And that's what Merrick Garland did in this case. Jack Smith was not part of the Department of Justice. He was appointed from outside the Department of Justice to be special prosecutor, as special prosecutors have been for years. But Judge Cannon says, well, don't point to that statute. That doesn't work. Then there's another statute. This other statute says, yeah, the Attorney General can appoint somebody from outside the government to assist a United States attorney. Now, this was interesting. Judge Cannon said, Special Prosecutor Smith has conceded that he does not merely assist a United States attorney. He has the powers of a United States attorney. So he has disclaimed reliance on this statute because he admits that he's not merely an assistant to a United States attorney. Now, this may have been a mistake on Prosecutor Smith's part. Maybe he should have said, you bet I'm an assistant to a United States attorney. Attorney General Garland could have decided that the U.S. attorney down in Florida could not prosecute this case himself because of potential, conflicts of interests affecting the entire Department of Justice. So he needed somebody to assist him. I'm going to appoint a special prosecutor to assist the U.S. attorney down in Florida. If Jack Smith had made that argument, maybe the complexion of the whole case changes. Maybe it comes out another way. But according to Judge Cannon, Prosecutor Smith did not make that argument, conceded that he was not an assistant to a U.S. attorney. And so Judge Cannon said, well, that one's off the table too. Forget about that statute. So those are two of the statutes. Judge Cannon knocked them off the table. Then there's two more statutes, and I'm not going to go into them in any detail here. It's a little complicated. Here's what I will tell you. She wrote a long 90-page opinion. Her analysis of these statutes, not crazy. She goes into the statutes, their wording, the legislative history in great detail. In each case, finds that they don't apply. But here's what you need to know. 40 years ago, the Supreme Court of the United States, in an opinion called Nixon versus United States, looking at those same statutes, says, under those statutes, the Attorney General of that time appointed a special prosecutor to investigate Nixon and did so validly. That is, the sentence says, the Attorney General, exercising his powers under these statutes, appointed Special Prosecutor Leon Jaworski to investigate Nixon in connection with the Watergate scandal. Then Jaworski issued Nixon a subpoena, and Nixon said, I don't have to follow that subpoena, executive privilege. And the Supreme Court, in this case from 40 years ago, Nixon versus United States, says, yes, you do. It's a landmark case. Executive privilege does not permit you to just ignore the subpoena. So the court upholds a subpoena issued by a special prosecutor and says that the Attorney General appointed that special prosecutor, exercising powers given to him under these statutes, naming the very same statutes that Judge Cannon is looking at. Well, question, was Leon Jaworski appointed from outside the government? Key question. If he wasn't, it's a totally different case. But guess what? Yes, he was. Like other special prosecutors, he had been picked out. He was a veteran prosecutor. He was picked out from outside the government and named special prosecutor. So very similar kind of case. Supreme Court, in a sentence of its opinion, expresses a statement which is pretty much squarely contradictory to what Judge Cannon is saying. Does Judge Cannon not know about that sentence from the Nixon case? Does she ignore it? No, she knows about it, and she did not ignore it. She wrote almost 10 pages on it. What does she say about it? She says, I don't have to follow it. What? A district court is saying I don't have to follow a statement made by the United States Supreme Court? How can that be? Well, here's what Judge Cannon said. She said that sentence from that opinion is dictum. Dictum? What's that, Professor? What is dictum? Well, I'm going to explain. It's a little technical, but for hundreds of years in Anglo-American jurisprudence, there's been this distinction. Within a judicial opinion, and judicial opinions can be very long, there is supposedly a difference between dictum, or plural dicta, in a case and the actual holding of the case. What's this distinction about? Well, when the court is addressing the case before it, everything it says about the case before it that is logically necessary to the decision that the court reaches, that's the holding. That's part of the holding. That's binding. That's precedential. But what if the court says something in the course of its opinion that is not about the case in front of it, but about some other facts or some other case. That happens too. For example, maybe a court will say, well, look, in these hypothetical facts, the law would be such and such. But those aren't the facts of this case. Here, in the facts of this case, here's what the law is. Whatever the court said about some hypothetical case, that's dictum and not precedential. That's the idea. If the court is making remarks about a case not before it, then that's not binding, and we call that dictum. Now, was the Supreme Court's reference to the Attorney General having exercised his powers under those statutes to appoint a special prosecutor, was the Supreme Court's statement that the Attorney General was doing that 40 years ago in the Nixon case, was that dictum? No, not exactly dictum. It was part of what permitted the court to uphold the subpoena that Special Prosecutor Leon Jaworski had issued. If Jaworski had not been validly appointed, he could not have issued a valid subpoena. So it was part of the logical steps necessary to get the court to reach the decision it reached. It wasn't some stray remark about a case not before the court. Now, Judge Cannon knows that. And here's what she says about the Nixon courts, the Supreme Court's statement in the Nixon case. She says, oh, okay, the court wasn't dealing with a whole other case not before it, but the court was simply articulating an assumption that it was making. So what Judge Cannon's doing here, and I told you it's a little complicated, she's running together the concept of dictum with the concept of an assumption. They're not really the same thing, but she does have a point. Here's the point. Sometimes in a judicial opinion, the court will rely on assumptions without actually deciding the point that's assumed. Let me make it very clear to you. The court will say, you know what? We're going to assume for purposes of this case that the special prosecutor was validly appointed. That issue, we're not deciding in this case. It wasn't briefed. We're not going to decide it. We're going to assume it, and then we're going to reach the issue that was briefed, the one that we're actually reaching in this case. Maybe in a later case, we'll resolve the question of whether a special prosecutor can be validly appointed. We're just going to assume it here. If the court says that, if it makes an assumption and says we're not deciding it, we're just assuming it, that also is not binding. It's not exactly dictum, but it's not binding. Assumptions reached in that way in a prior case are not binding. Did the Supreme Court do that? Did the Supreme Court say, look, we're going to assume without deciding that the special prosecutor has been validly appointed? No, the Supreme Court did not say that. They said that exercising the powers that the Attorney General had under these statutes, he had appointed and conferred special prosecutorial powers on Leon Jaworski. But Judge Cannon says, okay, the Supreme Court didn't expressly say that it was a mere assumption in the case, but I've looked at the briefing, I've looked at the case, I've looked at the arguments that were made, and the issue was never briefed, she says. Nobody argued it. Nobody claimed that the special prosecutor had not been validly appointed under those statutes. So the issue wasn't really reached, she says, by the Supreme Court, wasn't briefed, wasn't argued, and I'm going to treat that statement by the Supreme Court as merely an assumption concerning an issue that wasn't fully briefed and fully argued. Can Judge Cannon do that? Is she allowed to take a statement made by the Supreme Court and say it's a mere assumption and I'm not going to follow it? Have other courts said the same thing about this statement from the Nixon case? No other courts have said the opposite. The D.C. Circuit, a very important appellate court, in a case from just a few years ago, looking at another special prosecutor, looked at that same sentence from the Nixon case and said, that statement is binding on us. It's conclusive. The Supreme Court has told us that the Attorney General does have the power under these statutes to appoint a special prosecutor. So don't come to us making an argument he doesn't. That statement from the Supreme Court 40 years ago, that's binding and conclusive. That's it. Did Judge Cannon not know that the D.C. Circuit had said that? Well, of course she knew. And she addresses it. And she says that statement in the D.C. Circuit case was also not argued. Nobody had briefed it to the D.C. Circuit. Nobody had fully joined issue on that subject. No briefing was made. No argument was made. And I'm going to treat that as an assumption. So she's treating as assumptions the Supreme Court statement, other courts claiming that that statement was binding. She's treating all that as assumptions that she doesn't have to follow. So Judge Cannon She treated the D.C. Circuit's opinion on this issue, its statement, that the Supreme Court statement was binding and conclusive. She treated that as a mere assumption. She's treating the D.C. Circuit's statement on this as an assumption. She's treating the Supreme Court's statement on this as an assumption. She's saying, I don't have to follow any of this because it wasn't fully argued. Now, finally, it's been fully argued before me, and I am reaching these issues. I'm going through these statutes, which no court ever has before. I'm examining their text. I'm examining their history, and not a single one of them authorizes the Attorney General to appoint from outside the government a special prosecutor to investigate somebody inside the government. Case closed. Appointments clause violation. Special Prosecutor Smith was not validly appointed. He had no power to investigate. He had no power to initiate this prosecution, and I'm dismissing the whole case. Okay, now you understand what Judge Cannon said, what she did, what the legal issues are, what the various problems are. You can bet for sure that this case is going up on appeal. In fact, Special Prosecutor Smith has already taken the appeal to the 11th Circuit. What's the 11th Circuit going to say? I don't know. You never know what an appellate court's going to say, but here's something it could say. The 11th Circuit could say, you know what, it is not for us, the 11th Circuit, and it's certainly not for district court to overturn and call into question a direct statement by the Supreme Court of the United States. If the Supreme Court of the United States wants to decide that the Attorney General, contrary to what we said 40 years ago, does not have the power under these four statutes to appoint a special prosecutor, well, the Supreme Court can say that, but it's not up to us, an appellate court, to reverse or ignore what the Supreme Court told us 40 years ago, and it's certainly not up to a district court to do that, so forget about it. If the 11th Circuit says that, then in theory, the case would probably go to the Supreme Court. Don't know if they would grant cert on it or not, but if it goes to the Supreme Court, what's the Supreme Court going to say about it? After all, they have the power to reverse Nixon on this point and affirm Judge Cannon's ruling. What are they going to do? Well, once again, I have no idea what they would do if they ever hear the case. But in Judge Cannon's favor, there's Justice Clarence Thomas's concurrence from the recent presidential immunity case. Justice Thomas wrote a concurrence raising all the same questions about the appointment of the special prosecutor that Judge Cannon just answered by saying it's unconstitutional. Justice Thomas, in his opinion, strongly suggests that he considers it unconstitutional too, that he doesn't think that any statute out there authorizes the Attorney General to appoint a special prosecutor from outside the government and investigate a former president or anybody, and therefore the appointment would be unconstitutional under the Appointments Clause. He pretty much suggests all the same things that Judge Cannon just held, so that's in her favor. But against her is the fact that Justice Thomas's concurrence was a sole concurrence. That means nobody else joined it. They didn't all say, oh, we disagree with it, he's wrong. They didn't join it, however, and they could have, but they didn't. So we don't know if Justice Thomas is the only one who has these views on the Supreme Court. Other justices could have joined his opinion, but they chose not to. Well, that's the lay of the land, and now you know the full set of issues. I hope you understand it better. I got to close by telling you about the practical consequences of this case. The practical consequences are pretty clear. Practically speaking, it is now virtually impossible that this case will be tried before the election in November. That's just like Jack Smith's other prosecution up in Washington, D.C. on the January 6th case against Trump. Under the Supreme Court's recent presidential immunity case, however that's eventually decided, that's also going to delay things significantly, such that that case almost certainly cannot be tried before the election. Now, that's not the legal issue. The legal issue are these constitutional issues, and it is fair and proper for the legal issues to be fully vetted and to go through the appellate process. But here's the practical consequence. These prosecutions aren't going to take place. These trials aren't going to take place before the November election. And of course, after the November election, there may be an occupant of the Oval Office who sees to it that these prosecutions get dropped and never see a courtroom again. That's all from me for today. Hope you enjoyed it. See you next time.